Good evening, guys. So let's start with the session. Yesterday's session was about law of torts, as you all remember, and I left you at the defense of inevitable accident. I finished explaining it to you. Yesterday's lecture was primarily about finishing the remaining important topics under law of contract, and then we picked up law of torts. We discussed, of course, I introduced law of torts to you. Thereafter, the two basic and major principles on which liability is based under law of torts, that is injuria sine damnum and damnum sine injuria. Thereafter, we started discussing the various defenses under law of torts. Also, we discussed that what is really the relevance of these defenses as far as law of torts is concerned. So, in very simple terms, these defenses help an individual in escaping the responsibility of paying compensation. Alright, so since inevitable accident has been dealt with, before I proceed with the session, I'd like to ask all the students if they have any question as far as yesterday's lecture is concerned. Should I proceed straight away with the next defense? Yes, Shraddha, you want me to wait? Do you have a question? Alright, you can keep throwing in your queries and questions as and when you want to, and in the meanwhile we are going to pick up this session because we are slightly pressed for time. So let's begin with the next defense under law of torts, and as you can see on your screen, the next defense is act of God. Act of God is also known as vis major. So as far as law entrances are concerned and questions pertaining to the category of legal facts are concerned, you can expect a direct question that what is the other name for act of God. Your answer has to be vis major, or the question can also be phrased in a vice versa manner. Now, act of God. Act of God, the minute you hear act of God, we are talking about any kind of damage which is the result of the forces of nature. Forces of nature would obviously include what are the forces or elements of nature. There's wind, there's water, there's soil, etc. So whenever the nature behaves in a manner which is not predictable, in a manner that no human being can not only predict, but a human being can also not guard against such a behavior. So you know that the elements of the nature can sometimes acquire very dangerous dimensions, and that is when natural calamities occur. So whenever any damage is the result of a natural calamity like a storm, earthquake, a tsunami, or heavy rainfall, then no person can be made responsible for such a damage, because these damages are the result of that behavior of nature that nobody could have predicted, because the word that we usually use is unprecedented behavior. Unprecedented behavior means something that has never happened before. Now, when a thing has never happened before, you can't really be prepared for it. So that is why we give the benefit of vis major as far as defenses under law of torts are concerned. Let's look at the contents on the slide. Circumstances which no human foresight can provide against. Provide against means we are talking about defending. Okay, so you can't really protect yourself because the magnitude of these forces of nature is so huge that even if you want to, it is not possible for a human being to be able to protect himself or his property against such forces. Human prudence can't foresee, which means of course predict, and also they can't guard themselves against the damage. And of course it goes without saying that a human being also has no control over the event. Work of natural force which cannot be anticipated, again something that you can't predict at all. Moving ahead. Private defense is the next defense. Now, yesterday I made it very clear to you that law of tort isn't exactly a law in the true sense of the word. That means it is not an enactment where a legislature sat down and created a new law altogether. It is simply a collection of legal principles which have been evolved by various courts, and every country has adopted these legal principles as per their requirement, need and suitability. Now, we've already discussed private defense as a defense under the Indian Penal Code. So even with respect to crimes, an individual has been given the right to protect not only his life but also his property. Similarly, private defense is also a defense under the law of torts. So if you end up causing a damage to another person while protecting, what are the two things that you are allowed to protect? Just like the Indian Penal Code, you can protect your life and you can protect your property. But when you are exercising this right of private defense, the only thing that you are allowed to do is use reasonable force. And this force that you are applying, as the title of the defense says, it is private defense. So first of all, your application of force when you are exercising this right has to be very reasonable. Your aim at that time should be to only get out of that situation which is putting you under danger. So force has to be applied only for the purpose of defense. This is a really important point. You should never be the attacker first, or you should never be that party which is causing the damage. And hence, for such a resultant harm, there will be no liability. Let's proceed further and understand what are the rules that pertain to private defense. The following rules pertain to private defense. There should be an imminent threat to safety or property. Alright? And the force should be proportionate to the attack. So once you've made a calculation of the risk that you are under, your reaction to that risk has to be proportionate. Do not exceed your right of private defense. If somebody is attacking you and has no arms or weapons in his hand, it will definitely be disproportionate on your part to attack the person with weapons, with arms or a gun. So proportionality is extremely important. The next thing is, like I've already mentioned, the defense must only be a reaction. You should never be the party that acts. You should only be a party that reacts, and that too in the face of some kind of danger either to your life or to your property. And the right can only be exercised when no other choice is available. Please pay attention to this, that ideally causing harm to somebody's life or property is as good as taking the law into your own hands. So the law is giving you this authority, or the law is giving you this scope to basically damage somebody's life, or to basically damage somebody's property, or to harm somebody's life or somebody's body only in a situation where you yourself are first under an attack, and secondly, you should not have the choice to revert to anybody else for any kind of help. Alright, moving further, the next defense that we study is necessity. Now, as the very word tells you, necessity is a situation. You've heard necessity is the mother of invention. So whenever you are in such circumstances where you have no other choice but to take a quick action or to take quick decisions, if you go to the bottom of the slide, we straight away see throwing goods overboard a ship to lighten it, for saving the ship or persons on the board from sinking, or pulling down a house to stop a further spread of fire. So both these situations are examples of a scenario where ideally you would not throw goods overboard a ship, okay, just to lighten its weight, or you would not pull down huts or houses. But here the situation necessitates you, or the situation forces you to take these steps. So if you're able to justify this situation of necessity, you will get a defense as far as law of torts is concerned. Our final defense under law of torts is that of statutory authority. Statutory authority means any kind of authority that is derived from a law, because the word statutory comes from the word statute, which means an enactment or a law. Let's read the slide. When the legislature authorizes an act to be done, legislature is the law formulating organ of a government. So when the legislature creates a law and through that law or act it authorizes that a certain act has to be done, then if due to that act any kind of damage takes place, it will not be actionable even if it is a tort. By actionable I mean that the other party will not be able to claim any kind of compensation, because the damage was the result of an act which had been authorized by a law or a statute. Again, the statutory authority is a complete defense or a 100% defense. Injured party, however, can only claim the compensation that has been provided under the statute. So ideally there can be a situation that the statute or the law itself allows you to claim a certain amount of compensation. If the law is giving you that bandwidth or scope to claim compensation, fair enough. But if that's not the case, you will not be able to claim any kind of compensation. Let's understand this scenario a little better by going through this case. Well, the name of the case is right here on your screen. Hammersmith Rail Company versus Brand. Yes, Vanshika, I'm going to explain it to you. I am hopeful that once we read this case, it's going to become slightly clearer to you. And once I'm done reading the case, I'm going to relate the concept again so that it's absolutely clear to you. Okay, Hammersmith Rail Company versus Brand. The value of the plaintiff's property had considerably depreciated. That means the value had lowered or declined due to noise, vibration and smoke. This noise, vibration and smoke was produced by the running of trains on a railway track which was constructed under statutory powers. Now let's understand this scenario. The defense is statutory authority. Right? And I'm saying that if any act is done under the authority of law, so this railway track was constructed, of course, under the authority of a law or orders of the government. Now, because of the constant plying of trains on this railway track, a lot of noise, vibration and smoke was produced, and the complainant's property's value depreciated because of this noise, vibration and smoke. So now he wanted to claim a compensation from the government. But like I've already told you, statutory authority is a defense because this railway track was constructed under the orders of the government or the authority of the law. That is why nobody has to pay compensation even though the person's property's value had depreciated a lot. Okay, so the damage, like the slide says, was incidental to the running of the trains which had been authorized by the statute. No action lies for the same. I hope it's clearer to you now, Vanshika. Any doubts related to whatever has been covered under torts till now? Because after that I'm going to be proceeding with torts in relation to person followed by torts in relation to property. Any questions? Please put forward your questions, if any, related to contract or torts. Shraddha, estoppel is, rule of estoppel is a situation where once you've said something or once you've done something which made the other party believe you, okay, and as a result of the belief they ended up doing something further. Okay, so say for example a person says that I am from the income tax department and I have the authority to check your property papers and your bank account statements. Now because he misrepresents this fact that he is from the income tax department, you end up believing that person. Okay, now later on this person who misrepresented himself as an income tax officer will not be allowed to go back on his words and say that I never made such a claim. This is rule of estoppel. We study promissory estoppel as far as minors are concerned, but we say that the principle of estoppel or the rule of estoppel does not apply to a minor. That means a minor is allowed to go back on his words. Okay, so this is the only exception. Say for example a minor who is 16 years old misrepresents himself as an 18-year-old boy and borrows some money. Later on, he can easily escape the liability or responsibility of returning the money by saying that he was only 16 at the time when he borrowed that money. Okay. Like statutory right, fundamental right and moral right. Statutory right means any right that is created by a law, Joban, and fundamental right is also created under a law. So fundamental right is under the Constitution of India. Constitution of India, Indian Penal Code, Indian Contract Act, they are all examples of laws or statutes. So fundamental right is a kind or a type of a statutory right. Moral rights are something that spring up from your personal sense of right and wrong. They don't really have any presence in the law books as such, but they are based on your ethics and morality. Alright, can you please explain rules pertaining to private defense? Okay, I've told you that private defense allows you to defend your life and your property. So the point is that when you feel you are under some kind of attack or threat, you have to make sure that your first responsibility is to get out of that situation which is either threatening your life or your property. So for that purpose, you might have to hurt the attacker in order to protect yourself. But the rules are, first of all, you can only react. That means you can only defend. The title is private defense. So you're allowed to defend yourself. For that, it's important that you should be under an attack first. You should not making the attack first. Secondly, your defense has to be in proportion to the attack. That means if somebody is running towards you with a gun, okay, and you feel that there is a real threat to your life, and if you also happen to have a gun, you can shoot the person in reaction. But if somebody is running towards you completely unarmed, has no weapons, no sticks, nothing in his hand, and you still shoot the person in return, it is going to be a disproportionate use of the right of private defense. Clear? A contingent contract is a contract which is based on the happening or not happening of a certain event. Like insurance contracts are an example of a contingent contract. What happens under insurance contract? Say for example, you buy an insurance policy for your car. So it means that you are going to get a certain amount of money in two events. If the car gets damaged or if the car gets stolen. So the insurance company will fulfill their part of the promise only in the event of whether a car gets damaged or stolen. However, a wagering contract or a wagering agreement, because a wagering agreement can never be a contract. The best example of a wagering agreement would be betting. Okay, so you know how betting is illegal in India, and it's a huge racket where people bet money. So they would probably say that if a certain, say for example, if Sachin Tendulkar scores 100 in this match, I am going to get this much money. If he doesn't score this much, then I am going to give this much money. So again, the best example of a wagering contract is betting in sports. So in this case, the condition on which the give and take of money depends is completely unrelated to the party. So wagering agreements are illegal in India. Space, I just explained to you. No, a contingent contract is not void. A wagering agreement is void. Because contingent contracts, I just told you, an example is insurance policy, right? So those contracts are not void. Clear? Any other question before I move further? Okay, great. Now we are going to come on to the next important category under the law of torts. That is, what are the kind of torts that can be committed in relation to a person. Alright. So this is the overview. That means primarily we are going to be studying the following torts against a person. There's assault, battery, defamation, nervous shock, negligence and nuisance. So again, I'm going to focus on one thing, that you have to be conceptually clear as far as these 6 torts against human life or human body are concerned, because if you're conceptually clear, you're going to be able to attempt the principal fact questions very easily. Let's start with our first tort against a human body, that is assault. Now, we also studied the concept of assault under IPC, right? As far as assault under IPC was concerned, it is exactly based on this concept of assault that is under law of torts. So in IPC, we discussed that when you create a fear in the mind of an individual, that force is going to be used against him. Okay, किसी के मन में एक डर पैदा करना that he might get attacked. Okay, so that creation of fear is known as assault. So there is no actual physical contact with the person. You simply create a fear in the mind of the individual. Holding somebody on gunpoint, there is no physical contact. You simply point the gun in the direction of that person, and throughout that time, the one fear that is created in the mind of that individual is that a bullet is going to be shot through his head at any minute. Alright, so if you look at the first point on the slide, it says there is no actual use of force. Alright, so the key point here is there is only a creation of fear or apprehension. Manvi, all the e-lectures that have happened so far, they are live on YouTube now. Okay, so you can watch all those e-lectures all over again, and they should be enough for your clarity. Also, we have enough concept lectures and strategy articles on our website, so those should help you a great deal at this point of time. So the e-lectures you've missed so far, they are available on YouTube. So once an e-lecture takes place in a span of 1 or 1.5 days, they go live on YouTube. So if you've missed anything at all, you can watch those live e-lectures all over again. Clear? Okay. A foreign ship comes up to 6 nautical miles from the coast of India. It turns out to be a scientific expedition tracking the movement of dolphins. Is it violating any rule of international law? See, of course, Jobanpreet, as far as IP international law is concerned, so we have certain amount of space as far as in the air is concerned and also in the water. So we have this equation of 200 nautical miles and 12 nautical miles. Now as far as this question of yours can be explained more clearly in reference to a principle if there's given at all. So ideally every ship that enters the water space, okay, or water territory of the country, the naval guards who are keeping a watch, okay, on our coastal territories and our water territories, they have to get in touch with such a ship, okay, or such a water carrier, and once their intention is just to track the movement of dolphins, then there is no real violation of any rule of international law. Ideally this should happen under a permission, but again we do look at the fact of malified intention. Okay, so until and unless they are only tracking the movement of a certain animal, it is not going to be an out and out violation of an international law. The difference between fraud and misrepresentation is that of an intention. I've told you, in fraud your intention is to deceive or cheat the other person. In misrepresentation your intention is not so. Anshuman, I'm only going to be taking doubts related to contracts and torts, but I'll still quickly answer this. In robbery you have to actually go yourself and you have to either cause the death or wrongful restraint, or you have to cause hurt while actually stealing. Okay, but in case of extortion your own actual physical presence is not required. You can carry out an extortion even over a phone call where you ask a certain person to give you a certain amount of money, right? But for robbery the thief has to actually be present himself and he has to take away the movable property himself. In extortion, however, the victim will make sure that he transfers the money or the movable property in the favor of the extortionist himself. Yes, Vanshika, assault is punishable even under torts and under IPC. So you're just, even though you're simply creating a fear in the mind of the individual, but it is still a punishable offense under the IPC and it is a tort which can make you claim a compensation. Alright, assault, coming back to the slide. There should be a prima facie ability to harm. So this thing or this person which is creating a fear in your mind, okay, it has to look like a real risk. Now somebody who's standing at a distance with, say for example, a gun in his pocket and he's not even looking at you. Now here, just because you feel yourself that what if he comes and attacks you, in this case you are not under a real threat. Okay, until and unless the person actually points the gun at you, that is when the situation of assault starts. That is why I've said prima facie ability to harm has to be there. Now let's look at the examples. A advances towards B with clenched fists but is stopped by C. An assault has been committed by A. So clenched fist would mean to draw your hand into a fist. So if one individual approaches the other with a clenched fist, the person he's approaching is obviously going to have this feeling in his mind that he is going to punch him, right? So this feeling that he has created is assault. Then pointing a pistol, whether loaded or unloaded, towards the plaintiff is an assault. Okay, so when a pistol or a gun is loaded at you, you are not concerned whether the gun is loaded or not, neither can you ask the attacker this question, right? So your only concern at that point is that you might get shot. Okay, you cannot ask the attacker whether the gun is loaded or not. So this is also assault. Okay, the next tort is battery. All right. Ma'am, mistake result in Khushi, mistake, that is, you can be mistaken about the subject matter, identity of parties, or nature of promise. In all these three situations, the contract becomes void. However, in the case of coercion, undue influence, fraud, and misrepresentation, the contract is voidable. Anshuman, conversion and fraud are completely different things. Conversion is when you deal with somebody's movable property in a manner that you're not supposed to, and fraud has the element of cheating in it. Okay, so there are two different things. Alright, battery. Now the minute, I've told you under assault, you basically create a fear in the mind of the individual. Now battery is the next step. If you look at IPC, battery is very similar to the concept of criminal force. Okay, so this is where a physical contact gets established. So intentional application of physical force. Of course, when you create this physical contact, it is without the consent of that person on whom you are applying this force. Of course, an application is also without any lawful justification or a logical cause. Now, A hits B by throwing a stone at him. This is battery. Or if X spits on Y's face, this is also battery. Now, when we study criminal force under the IPC, and I've already told you that criminal force is very similar to battery under torts. But as far as IPC is concerned, the IPC will not entertain minor pleas like if somebody has pricked another individual with a needle or somebody has nudged another person with an elbow. But under torts, under battery, it's similar to criminal force, even such sensitive pleas or trivial pleas are entertained. Clear? Now what is the difference between assault and battery? In case of battery, there is a physical contact, and in case of assault, there is no physical contact. You simply create a fear in the mind of the individual that I might create such a physical contact with you which is going to either harm your body or your life or your property. Clear? Ankita, what do you want me to explain? Shraddha, the difference between battery and criminal force is battery is very similar to criminal force. Criminal force is a concept we study under the Indian Penal Code, which is a completely different law. We've already covered this in our first e-lecture, so you can always go and watch that video for some more clarity. And battery is a similar concept but under a different law, that is law of torts. Okay, the difference between criminal force and battery ideally is that battery, even a small minor physical touch is included, but in criminal force, trivial complaints are not entertained. Like I gave you an example, if you were considering criminal force, then pricking somebody with a needle will not be considered. But if you are considering torts, then pricking somebody with a needle will come under the category of battery. Purnima, all these videos are available on our channel Hitbullseye on YouTube. So once you've accessed the channel, you can search for not just videos related to law but also videos related to English, maths, reasoning. Clear? Ankita, I'm still waiting for you to tell me what is it that you want me to explain to you. Okay, battery. Ankita, okay, I'm going to explain battery again to you. Battery is when you make any kind of physical contact with another party without the permission of that party, and that physical contact has no logical reason. I have given you these examples. If A hits B by throwing a stone at him, it's a physical contact through a stone. Again, it is of course without the permission of the person who's being hit by the stone. And spitting on somebody's face is again battery. Okay, physical contact. Okay, not direct but through spit or through stone. Clear? Anshuman, I have made it very clear even previously that today I am only taking doubts related to torts and contract, that also sparingly. Anshuman, Article 32 is also available to non-citizens, because Article 32 is available in the situation when your fundamental rights get violated, and fundamental rights like Article 14 to 18, which deal with right to equality, they are also available to non-citizens. Article 23 and 24, rights against exploitation, they are also available to non-citizens. So when they'll get violated, even a non-citizen will have the right to file a writ in the Supreme Court. Alright. Anshuman, my last e-lecture, that is on Monday. Alright. I am going to be taking any kind of doubts that you have related to strategy or any other subject. That's not a problem. Anjani, you'll have to go back and watch a e-lecture on IPC. That's the first one, and I've covered criminal force in it. So Anshuman, on Monday I'll be taking miscellaneous doubts. Alright. Okay, assault versus battery. Now let's look at the difference between the two. Now the first difference is, in assault there is no physical contact, but in battery there is a physical contact. Now generally every battery includes assault. So before you actually create a physical contact with someone, or you apply any kind of physical force on another individual, it is usually preceded by the creation of fear in the mind of that individual. However, every assault may not lead to a battery. Sometimes you may simply create a fear in the mind of the individual, and that might not lead to the actual application of criminal force. Like in the previous slide we discussed that if somebody is approaching another individual with clenched fists, something like this, which is a clear sign that he might punch the other person, but if somebody stops him from doing so, now this assault has actually not resulted into a battery. So let's read this illustration. Pulling away a chair from one who is about to sit on it is an assault until he reaches the floor. When he comes in contact with the floor, it's battery. Okay. Can we take the cases related to battery cases in court? Surbhi, of course you can take cases related to battery in the court, but under law of torts only, and the charges you will file will also be called battery. Clear? These are minor cases like the needle one. Is this relevant? Yes, it is relevant under law of torts. Like I mentioned, if you would file the same case under the Indian Penal Code under criminal force, then the court will not take notice of it. But under law of torts, under battery, notice would be taken. Alright. The next tort that can be committed against an individual is defamation. Surbhi, as far as punishment is not the word we use as far as law of torts is concerned. The only kind of word we use here is compensation in the form of unliquidated damages. So a person will be paid some kind of financial compensation, but not any kind of punishment. Now, defamation is a tort that is committed against the reputation of a person. Okay, so the first line on the slide says that every individual has a right to reputation. Okay, now what is the difference between reputation and character? Character is something that you are, and reputation is how you are viewed in the society. So defamation will ultimately affect your reputation or how you are looked at in the society. That's why our second point says that defamation is basically injury to reputation. So there are two kinds of defamations that happen. Okay, defamation can either be categorized under libel or slander. So if you look at the bottommost point, it says libel is addressed to the eyes and slander is addressed to the ears. So if libel is being addressed to the eye, that means the defamatory statement is permanent in nature. Like it could be something that you've written, a picture, or anything that has been printed. So this is permanent. You can see this, you can read it or watch it again and again. However, slander is addressed to the ear. So I would say it is transient. Okay, spoken words, they're spoken and over. So, but these are the two forms of defamation. So be very clear. Libel is addressed to the eye and slander is addressed to the ear. So sometimes you can get a direct question as far as this principle is concerned. What are the essentials whenever you go forward and you want to make a claim? As far as the Manvi, I just gave you an example. Please concentrate on the slide. Anything that you write, say for example you write a book and you write something defamatory in that book, it becomes libel, okay, because it's permanent. Somebody can read that book again and again, okay. Or if you've printed pamphlets or any kind of literature which has anything defamatory written about another person, it's going to be liable. As far as slander is concerned, if I make a speech in front of 20 people, okay, now this is not permanent. I've spoken the words, once spoken, they are over. Nobody can reread them again and again. They are not in a permanent form, they are in transient forms. Spoken words are transient in nature. So that is why two categories have been given, libel and slander. Okay, defamation. Now what are the essentials of defamation? The statement has to be defamatory. How do you come to know that the statement is defamatory? Once it targets a person's reputation, and by reputation I mean space. Now I'd like you to focus on only questions related to torts, because now we're dealing with core areas of torts, so you can take these up in your miscellaneous doubts, okay, in the next lecture. Manvi, there is obviously going to be proof. The people who've heard these words can appear as witnesses in the court. Clear? Purnima, once a speech has been filmed, then it converts into libel. Okay, the essentials. The statement must be defamatory, that means it must target an individual's reputation. The statement must refer to the plaintiff. So A has to specifically make a defamatory statement about B. Okay, the statement must be published. Now it's really important. This is the most important element, that a defamatory statement has to be published. Space, I'm really sorry, I'm restricting my doubts to just torts now. I'm going to explain this to you in the miscellaneous section on Monday. We have a lot of work, we have a lot of concepts that need to be clarified right now, so I will really respect it if you now restrict your queries to just law of torts, okay. Otherwise this is breaking the flow of the lecture again and again. So I'm really sorry, but I'll be taking it up with you on Monday. That's a promise. Clear? The statement must be published. That is, you don't have to actually publish it in the newspaper, or you don't have to necessarily print a novel out of it, as long as it comes to the knowledge of a third person. So it means that if there are A is making a defamatory statement about B, so that does not mean that he has to actually publicize it or tell the whole world about it. Even if C comes to know about this defamatory statement, our element of publication has been satisfied. Clear? Then we have certain examples of defamation, and we will see how the element of publication works. A tells B in the presence of C that B is a prostitute. Okay. Now the fact that A is saying this to B in the presence of C, so this presence amounts to the ingredient of publication. Or A writes a defamatory letter about B and B happens to be blind. Okay. Now he has written a defamatory letter to this individual who happens to be blind, and he knows it really well that the person is blind. So when the wife reads it for the blind man, so the fact that wife is the third party who comes to know about the defamatory statement, again our element of publication has been fulfilled. So this is going to amount to defamation. What are the various defenses? Say for example, when a party is accused of having made a defamatory statement, what are the various type of defenses that are going to be available to that party? Well, these are the three defenses on your screen which will be available. The first one is truth, the second one is fair and bona fide comment, and the third one is privilege. So of course your first defense is that whatever you have stated, even though it might be defamatory in nature, but it was the truth. Okay. Then your second statement is a fair and bona fide comment, means that sometimes you have to speak certain statements. They might be defamatory to a certain individual, but those statements or those remarks have to be made in the larger interest of the public. Space, if you've made a defamatory statement, it has lowered somebody's reputation, but if it is the absolute truth, then you will not be liable for making such a statement. Okay. Then the third situation is privilege. There are two types of privileges that we have to target upon. There's an absolute privilege and then there's a qualified privilege. Now an example of an absolute privilege would be Article 105 Clause 2 of the Indian Constitution. Is just an example that members of the Parliament, that is the Lok Sabha and the Rajya Sabha, now when they are participating in the business of the house, and I mean when the house is in session, then during discussions they have 100% freedom of speech and expression, meaning thereby that even so during the process of a session, if they end up making a defamatory remark, then in that case, even though it is defamation, but they will get the defense of having an absolute privilege under Article 105 Clause 2. Then the second one is a qualified privilege, statement made in order to protect one's interests. Now sometimes you have to reveal to somebody a certain fact about another individual to watch out your own interest. For example, you run a business and you have a manager who basically takes care of all the orders that are placed. Now, say for example, there has been a party or there has been a customer who takes goods from you but never pays. Okay, so he takes goods on credit from you but never pays for it. Now, if the next time when you hire a new manager, you can always tell the manager that, look, please do not give this person any kind of goods on credit. Make sure that he pays you money, because he is known for not ever paying money to anybody. Now, if you look at it as an isolated statement, it is defamatory. To tell a certain person that, this person never pays money, it's defamatory, it's going to affect his reputation. But here the businessman is doing so in order to protect his own interest. Alright? Okay, ma'am, the example we just did, in that it might be true that the other person is a prostitute, then will it get defense? That's what I'm saying, Megha. If you made a true statement, then it will not be defamation. Clear? Kapil Sharma said on Twitter, maybe ask something from our Prime Minister. There is a case going on him, after that it is a MAT. Why? Manvi, could you clarify your question a little more? The third defense, privilege. Okay, privilege. Now sometimes you may have the privilege, okay, you may have that exclusive right to speak what you like. Sometimes the privilege is absolute, that is 100% or complete privilege, like in the case of Article 105 Clause 2, where the members of Rajya Sabha and Lok Sabha have 100% freedom of speech and expression. So during the sessions of the Parliament, when the House is in business and discussions are going on, even if these members of the Lok Sabha or Rajya Sabha, they end up making a defamatory statement, the member who makes such a statement will not be liable. So this is an absolute privilege and absolute defense. Clear? Qualified, statement made in order to protect one's interest. That means where a businessman tells his owner that to a certain party do not give him any kind of goods on credit, okay, because he never pays. So this statement that never give him goods on credit because he never pays is defamatory in nature. But the businessman has to make this in order to protect his interest, because otherwise the manager is going to end up giving him goods on credit and he will suffer a loss resultantly. Clear? Manvi, I'd like to know that what was the tweet about? I've read your question, but it will make things easier for me if you can give me some clarity that what was the tweet about. A lot of cases regarding defamation are filed in the court every single day, but the point is, it is the court later on which gets to decide whether it's defamation or not. Clear? Yes, Purnima, absolute privilege is only during parliamentary businesses going on. If that member of the parliament is standing outside and giving an interview, at that time he will not have this absolute privilege. The next kind of tort that can be committed against a person is nervous shock. Acute shock to the nervous system. So your nervous system includes the brain and the spinal cord. Now your brain or your nervous system has to suffer such a shock because of a certain incident. That impact on the brain actually starts showing on your body in some form or the other. It might lead to a depression, it might lead to a fever, it might lead to your complete mental breakdown where you are hospitalized. A person might suffer a heart attack, etc., etc., as a result of the nervous shock. So that's why the second point says that resultantly activities of the body are impaired or functioning of the body is incapacitated. So till the time that impact on your nervous system does not show on your body, it will not come under the category of a nervous shock. Okay, there can also sometimes be a resultant body injury. Okay, Jobin, you're saying, ma'am, he said he gave 10 lakh rupees bribe to a government employee in the Kapil Sharma case. Okay, Jobin, so if he's made an open statement like this that he has had to give 10 lakh rupees bribe to a certain employee, then if his statement turns out to be true, then it's not going to be defamation. Okay, but if he's unable to prove his point, then it's not going to be, then it's going to be defamation. Clear? Vanshika, can you explain nervous shock? So I've told you the nervous system includes your brain and the spinal cord. Okay, then sometimes certain events happen which have a straight impact on your brain. Some people see something or hear something and they faint. Some people get heart attacks. Some people, they experience a nervous breakdown, they get admitted in the hospitals. Some people suffer heart attacks, some people slip into a depression. The point is, nervous shock will be considered only when it actually shows an effect on the body. The next case I'm going to be reading on the next slide is going to make it clearer. Okay, Vanshika and Space, this is for you guys. In the case of Borehill versus Young, please concentrate on the facts of the case. The plaintiff, a fisherwoman, was unloading baskets of fishes from the cart. Clear? She saw a motorcyclist go past her in top speed. A short while later, she heard a collision. She went towards the accident spot and saw blood spluttered all over. She suffered a nervous shock as a result of it. So what are the facts of the case? That basically there was a fisherwoman, and you'll understand that when all of this happened, she was carrying a child, means she was pregnant. So there was this pregnant fisherwoman, and when she was doing her day-to-day job, she saw that this motorcyclist sped past her, and in a few seconds she heard this collision. Okay, then she walked towards the spot where the collision had taken place, and then she saw blood splattered all over the ground. Now I've mentioned that she was pregnant at that time. So when she saw all that blood, okay, she experienced a nervous shock, and ultimately this resulted in the fact that she delivered a stillborn child, or a child who was dead at the time of birth. Now she sued the motorcyclist. Now ideally, the case definitely is a good example of how sometimes an outside event can really affect your nervous system, which can ultimately have an impact on your body. But she was not allowed to take a compensation from that motorcyclist, because you are only liable for the direct consequences of your act. So the motorcyclist is definitely liable towards any person who he injured because of his motorbike. But somebody who's standing on the side, okay, somebody who's a passerby who has simply who has simply witnessed the accident will not be able to get compensation. However, this case has been quoted here that sometimes incidents of such a huge magnitude take place which have a physical impact on the body of an individual. Alright, then there's a case of negligence. Megha, say for example, you are told that somebody is playing a practical joke on you, and the person says that A tells B, okay, A tells B that B's husband has met with a very, very serious accident and he's admitted in the hospital. Now this news is going to have such a huge impact on the nervous system of the wife, and there may be a chance that she slips into, she experiences a nervous breakdown, or there have been cases where people experience heart attacks because of such sensitive news. Now in this case, this impact on her nervous system has ultimately led to a damage, okay, physical damage, where she slipped into a nervous breakdown, depression, or a heart attack. Okay, so when your nervous system is impacted in such a way that ultimately it starts showing on your body, it comes under the category of nervous shock. Megha, I'm saying if it's not true, because truth is always a defense, but if it's not true, Ma'am, what if A was running and he hit B because he lost balance, but B died since she was having heart problem? Yes, Purnima, then he will have to compensate the woman. Ma'am, any example of nervous shock? I just gave you an example where the person will get compensation, because if somebody is playing a practical joke on you and saying that your husband has met with an accident, and then you experience a heart attack or any kind of medical condition, you experience a nervous breakdown. Now here the statement was not true regarding the accident of the husband, so that is why a person will get compensation. Alright, great. Then the next tort that can be committed against a human body is that of negligence. Okay, breach of legal duty. Now under negligence you have to prove the following things: that you were under the legal duty to either do a certain thing or not do a certain thing, and because you were careless, okay, you failed to take reasonable care, you were careless. As a result of the lack to follow your legal duty carefully, there was a resultant damage. So what are we really looking at? A legal duty is breached and it results in a damage. Let's proceed further. Panchika, yes, defamation is also an offence under the IPC. Yesterday in my e-lecture I had explained to you that torts is a collection of principles, and a lot of torts have been adopted in our country. So you will find assault has been adopted under IPC, battery has been adopted under the name of criminal force, defamation has been adopted as it is. Jobanpreet, care of the neighbor is a basic principle that we study under torts, that like you have the right to enjoy your property peacefully. Similarly, you must also respect that the fact that your neighbor has the same right. So you have a duty of care towards your neighbor. You have to be careful that you do not interfere with their right to enjoy their property. Moving ahead with negligence. The next example is that of Donahue versus Stevenson. Very, very important case. Even the title of the case is really important. A lot of the consumer laws in India can be related back to this case. Let's read the facts of the case. Very interesting. Also, CLAT has time and again asked this question directly under the principal fact category. Okay, let's read the slide. A man bought a bottle of ginger beer for his girlfriend, which is manufactured by the defendant. The lady drank the contents of the bottle directly. Later, she poured the remaining contents into a glass. To her utter shock, she noticed that a dead snail was popping out of the bottle. She fainted and fell ill, as she had already consumed a portion of the drink. Now, this is a beautiful example of a combination of negligence plus nervous shock. Now, when she saw, because the facts of the case is that this girl was drinking a liquid content from the can itself, that is ginger beer. Later on, she poured the remaining beer in a glass, and when she was pouring the remaining beer in the glass, she saw that there was a dead rotten snail. Now this is an incident where her brain sends such extreme signals to her body that she immediately fainted and she was sick or she fell ill. Now in this case, the manufacturers of the ginger beer have been negligent. Why have they been negligent? Because if we go back to the previous slide, they have a legal duty. Okay, they have a legal duty to make sure that they deliver quality products, right? It's their duty to deliver quality products to the customers. Now they have obviously not taken reasonable care. It can only mean a lack of reasonable care or a lack of following the standard procedures that a dead snail has managed to be there in a ginger beer can, and as a result the customer has suffered damage, right? So this is a case of negligence, and I've told you that most of our consumer laws today are based on this concept, which is evolved under the case of Donahue versus Stevenson. Okay, so ideally when you are trying to claim compensation under the tort of negligence, you have to prove the following things. First of all, that the party has the duty to prove that the other party was under a legal duty to follow certain guidelines or procedures. Then the second thing they proved was that they did not follow the standard guidelines or procedure, and as a result of it there was a damage. Now the maxim is res ipsa loquitur, which means that the thing speaks for itself. So sometimes you don't even have to prove that a certain party was negligent or not. Okay, the things are so evidently clear that you don't have to prove that somebody actually faltered as far as following the legal duty was concerned. So in these cases the plaintiff isn't required to do so. That means the burden of proof in case of res ipsa loquitur does not lie on the plaintiff. The event or the accident speaks for itself. The plaintiff only has to show that an accident occurred. Yes please. Ma'am, but they don't open the seal of each bottle and check its contents. Shraddha, they don't have to. The point is they have to make sure that whatever they are putting inside the can is of such a good quality that there is no scope of a dead snail. You must have seen the kind of controversy that has been going on about pesticides being found in your aerated drinks like Coke and Pepsi. So here the manufacturer's duty is to make sure that you are getting a quality product. I mean, they can't say that we can't check every bottle and can for a dead snail. When you are buying a certain product, it's their duty to make sure that you get the best quality product. Otherwise, no company is ever going to take responsibility for customer care, right? So they have to make sure, how can a dead snail in the first place go inside a dead can? Of course, they're not supposed to open every can and see it. But when they were shutting the can, is it not their responsibility to see that the quality of the product inside the can is good? It must have gone in it at the time of its manufacture. That's why, Hina, you're absolutely right. Purnima, I'm still going to talk about res ipsa loquitur. But isn't it the fault of the manufacturer, not the seller or shopkeeper? Yes, Shraddha, it is the fault of the manufacturer only. We are not talking about the shopkeeper over here. The manufacturer was only made liable in this case. Okay, res ipsa loquitur is that situation, Purnima, where you don't have to prove that the person was negligent or he did not follow a standard procedure that he is supposed to follow. Things speak for itself. Now say for example there is a building, okay, there was a real life case that there was a tower clock, okay, or a clock tower, I'm sorry, a clock tower was there in a small town in UP, and that so you know, in the olden times watches and clocks were not really prevalent, so there used to be this huge a tall structure was created and on that they would fix a clock. So that clock used to serve the purpose of basically being the public clock, right? So the structure that was erected, it is the duty of the municipal corporation to take care of that structure. So if one day that structure collapses, right, and a few people get injured or they die as a result of that collapse, here nobody has to prove that the municipal corporation did not take steps to make sure that that structure was maintained. The fact that it collapsed, it speaks for itself that the structure was not properly maintained. So sometimes things, they speak for itself. You don't have to prove anything. Alright, this is a concept under the topic of negligence. Manvi, under the Consumer Protection Act, retailer is not liable, always manufacturer is liable for any damage. Now see, ultimately if you look at the brand Cadbury, so they supply every retailer with this small refrigerated box. Or if you look at Coke and Pepsi, they are supplying fridges to the shopkeepers. This is to make sure that the product reaches the end consumer with the same quality level with which it was manufactured, because ultimately it all boils down to the manufacturer. The manufacturer has to take due care, and the care or his responsibility lies ultimately towards the end consumer. Alright, nuisance. So we're coming on to our next tort that can be committed against a person. Unlawful interference with a person's use or enjoyment of land or of some right over it or in connection with it. Now I know I've already told you that you all have the right to peacefully enjoy your property, okay? So if you are living in your house and somebody constantly plays loud music. Okay, so here nobody has to actively be on your property to interfere with your use of your house or rights associated with it, but the fact that somebody is constantly playing loud music in the neighborhood, that is interfering with your right to peacefully live in the house. So such acts come under the category of nuisance. Okay, what are the various examples of nuisance? There can be smokes, fumes, smell, heat, or anything that interferes with the health of others. I've given you example that if loud music is played, that is also an example of nuisance. Public nuisance. Anjani, what do you want me to repeat? Alright, I'll explain nuisance to you. As a slide, please take a look at it. Unlawfully interfering with a person's use or enjoyment of land or of some right over it. That means when you have a property, you have the right to peacefully enjoy that property. That's why I gave you an example that if you live in your house, you have the right to live in it peacefully. If your neighbor constantly plays loud music, okay, then you will not be able to enjoy your house and the rights associated with it peacefully. And other examples are smoke, fume, smell and heat. If some activity is going on in the neighborhood because of which constantly smoke is produced, or chemical fumes are produced, or some foul smell is produced, now you have the right to peacefully live in your house without being subjected to loud music or constant smoke or bad smell. Okay, so this will amount to nuisance. Hina, we are studying torts, and under torts the word that we use is not punishment. Please, I'm repeating it for everybody's purpose. The word that we use is compensation or unliquidated damages. It is always in the form of money. Okay, so you can seek compensation in case of nuisance. First of all, the first thing you will request from court is that your neighbor should stop playing loud music, and you can also seek a compensation after that. Under the law of torts, there is no imprisonment in jail. There is only compensation in the form of money. Clear? Alright, what are the two types of nuisance that can take place? The first type of nuisance is public nuisance. So I've already told you what nuisance is. If nuisance targets one person, it is going to be private nuisance. But if that nuisance activity like loud music, smoke, fumes, they start affecting a lot of people, of course it will become public nuisance. So causing common injury, danger or annoyance to the public or to the people who occupy a property in the vicinity. Any act which endangers the health, safety and comfort of public. Purnima, that's a very good question. In fact, my very next slide is going to answer this question to you, that when religious places they use loudspeakers, will that come under the category of nuisance or not? Okay, let's first look at the essentials. To make nuisance an actionable tort, you have to prove that there's a wrongful act, injury and damage or loss and inconvenience is caused due to this wrongful act. Injury is direct and of a substantial nature. Okay, so if you look at this case, Purnima, Soltau versus Deheld, in a locality there was a chapel whose bells kept ringing all the time without a break. This caused nuisance to the residents of the locality. The court ordered the chapel to ring the bell only at specified timings. Okay, so in this case the church bells used to be rung all the time. Okay, they kept ringing all the time. So the residents of that locality, they filed a case. So now the court ordered that the chapel must make sure that these bells are rung only at specified timings. So you must have noticed that until and unless these religious places also have a specific permission from the authorities, they use loudspeakers at specified timings only. Shraddha, if the specified time includes 4 in the morning, then it is not going to be nuisance. Alright. Yes, it will not be classified as nuisance. If their religion demands that the bells have to be rung at 4 in the morning, then the bells will be rung at 4 in the morning, because we can't ignore the fact that we also have the freedom of religion in India. Okay, from Article 25 to 28 under the Constitution of India, we have the complete freedom of religion. So if your religion requires you to ring certain bells at 4 in the morning, and if it is given permission by the authorities, then it will not be nuisance. Aditya, in case of public nuisance, see, if there has been some actual damage, somebody's health got affected due to say loud music, or somebody developed some kind of a respiratory disease because of constant smoke. So in this case, the person will also get a compensation. But say somebody has been just constantly playing loud music and there has not been any kind of actual damage as a result of that, then sometimes just a court order to that neighbor to stop playing that music is going to be enough. Okay, so compensation may not always be the case. Okay, the next type of nuisance that we are going to study is private nuisance. Now, it is some unauthorized use of a man's own property. So, you are carrying out a certain activity on your property, like I said, playing loud music, or doing some activity on your property because of which a foul smell is produced or chemical fumes are produced. It comes under the unauthorized use of a man's own property. As a result, causing damage to the property of another, or some unauthorized interference with the property of another. Okay, but does not amount to trespass. Like I've told you that the difference between nuisance and trespass is that in trespass, the individual has to himself be physically present on the property. But as far as nuisance is concerned, you don't really have to physically be present on somebody's property. The simple fact of playing loud music is enough to cause nuisance or discomfort to another individual. Purnima, anybody can file a case as far as public nuisance is concerned. There can be one person who may file a case on behalf of the rest of the locality, or they all may combine and file a case together. So there is no clear-cut rule. Anjani, trespass is when you enter somebody's property without that person's permission. Okay, when you have to be on, when you decide to be on somebody's private property, you should either be invited by that person on the property, otherwise you are going to be a trespasser. Okay, trespasser means to enter onto somebody's private property without that person's permission. Okay, causing abnormal noise may cause discomfort to the neighbors. Now, let's read a case to understand this better. In this case, the plaintiff was a music teacher and she gave music lessons to her students. The defendant was her immediate neighbor. Now, she was a music teacher and she was giving music lessons to her students. The defendant was her neighbor and was disturbed on account of these classes. Now, till this point in the case, it is the music teacher who is creating some kind of discomfort for the neighbor. So, this neighbor who was constantly disturbed, she decided to retaliate by making noises, knocking on the wall to disturb the classes. Now, the minute, instead of going to the court and asking the court to ask the music teacher to take these music lessons at specified timings only, she decided to take the matters into her own hand and she started making double the noise. Okay, so in this case, she is the one who becomes nuisance. Clear? If a branch of poisonous plant enters others' property, yes, Vanshika, it's going to be nuisance. Definitely nuisance. Because it is just like music that you're playing on your property and the sound waves reach the neighbor's house. Similarly, if you plant a tree and if its trees or branches start protruding on the other side, it's definitely going to be nuisance. In fact, if say for example, an animal is there on the property and he ends up nibbling on the leaves of those poisonous trees, then it is going to be a clear-cut case of nuisance, in which case the owner of that animal can also claim a compensation. Private nuisance ultimately is interference with the use or enjoyment of land or some right over it. Plaintiff must show title to the thing to which nuisance has been alleged. So basically, you should be able to prove that if I am living in this house and the fact that somebody constantly plays loud music, it interferes with my peaceful enjoyment of my right over the house, you have to prove that this house belongs to you. You should either be the owner of the house or you should be a lawful tenant. The act complained of must result in damage. Now, nuisance is not actionable as per se, but you have to prove some kind of damage. Damage could also mean where the constant ringing of bells in the chapel does not let people sleep. So it is depriving people of the right to sleep. One must not make such use of property. So the whole concept of nuisance is based on this principle, which is at the bottom of the slide. One must not make such use of property as unreasonably or unnecessarily to cause harm to the neighbor. Anjani, I'll take you back to the case. 1 minute. In this case, the music teacher was being nuisant. I told you that up until this point, till the time she was taking music classes, she was the one who was causing nuisance. So it was the duty of the neighbor to basically complain, okay, to the correct authorities, to the right authorities, that this noise irritates me and some kind of action should be taken. Instead, she decided to take matters of the law in her own hand and she started making noises at her own house. So in this case, she is the one who becomes nuisant. Clear? If a tree in someone's property is bending towards my house and possibly it will fall during a storm, is it nuisance? Yes, Aditya, it's going to be nuisance because again it is first of all protruding onto your property. The fact that it is even protruding onto your property is nuisance, because you should not have the branches or trees from somebody else's property protruding into your house, ideally, because you have the exact authority to decide whether it can be the case or not. And if it falls during a storm, of course it is definitely going to be nuisance. Ma'am, if while practicing his or her religion a person or group pollute a river, is it public nuisance? Now this is a very interesting question. Of course it is public nuisance. The case that the whole controversy that has been happening as far as the NGT in Delhi and the Art of Living organization is concerned. So Art of Living had organized a huge event in Delhi, right? And as a result of that, the NGT has declared that that's what the NGT says, that they were very, very negligent and ultimately they have damaged the water as well as the land. Okay, they've polluted it. So of course it will amount to nuisance. See, right to religion or freedom of religion has to be balanced with a respect for the natural environment, because ultimately under Article 21 we also include the right to life and personal liberty. So they both have to be balanced. Right to religion is also a fundamental right, and your right to a healthy life and personal liberty, and for a healthy life you need a clean environment. Okay, so they can clash. Shivanshi, we just did statutory authority. Okay, as a defense. I hope you had joined the session by then. If any act is done under government orders, so if the government has planted certain trees, that has happened under the government orders, and against that you will not be able to claim any kind of compensation, or you will not be able to demand any kind of compensation against it. What's your question, Joban? Ma'am, I'm in the first year of law in Riyadh Bahra College. Can I do CLAT? Is it any benefit to leave this college and take admission in NLU? Jobanpreet, of course, with all due respect to the institution you're studying in right now, but in all honesty, there is no comparison of any other law college when you actually tout it against an NLU. So if you make it to an NLU this year, I would make a very honest suggestion to you that you should definitely go to an NLU and experience how studying law at an NLU is. So the fact that you studied at Riyadh for 1 year, I'm sure you've learned a lot here, and it will really help you when you're going to be at an NLU. But I would say that if you clear CLAT this time, you should definitely leave the current institution and join an NLU. You will really not regret leaving Riyadh and joining an NLU. Clear? And I'm not saying that Riyadh is a bad institute, but NLU, all the NLUs in India, they are the topmost when it comes to legal education. So if you are preparing for CLAT this year, the fact that you joined the session with me right now means you are. So don't worry about the year that you have been at Riyadh, because I'm sure you've learned a lot here as well, and it's going to help you in the next 5 years at NLU. For legal GK space, honestly, as far as legal GK is concerned, my best advice to you is that read the newspaper, because as far as legal GK is concerned, it is an aspect of general knowledge and general awareness. So if you've regularly read newspapers, okay, that's the only way you can identify specifically legal GK. Also, pick up any kind of periodical journals or magazines that come out pertaining to GK. Then there is a very good website called Live Law. So you can see the latest events related to the field of law that are happening, latest judgments, latest amendments, really good articles and blogs related to law on this website called Live Law. So that should take care of the current legal GK section of yours, okay? But any kind of GK, whether it's legal or your general studies, it requires consistency. Clear? All right. Okay, so I'm going to end this session. Today we finished the introduction to torts, the defenses under torts, and the torts that can be committed against a person or property. In my next session, that is on Monday, I will wind up the law of torts with you. I am going to cover torts related to property. I am going to cover that what is the responsibility of an owner of a property towards the people he invites to his property or to those who trespass into his property. Also, we will understand what is the responsibility of an individual if a damage is caused by an animal that he owns. Thereafter, I am going to be discussing a little bit of intellectual property rights with you, and I will be taking your miscellaneous doubts, and I'll be discussing a few strategy tips with you in my next session, that is on the 1st of May, and the time slot is 6:30 to 8 p.m. So I'll catch you guys at that time. Till then, keep practicing as many questions as you can and stay in a very, very positive frame of mind. Yes, Purnima, it's going to be from 6:30 to 8. Aditya, honestly, the entire substantial law is in your syllabus, but it's been my effort to discuss those subjects with you which are asked. I mean, questions from the subjects which are asked most often are IPC, torts and contract, and I have covered these three in detail with you. Monday's session is going to be about taking miscellaneous doubts. I'll be focusing on finishing torts and taking up IPR with you, and thereafter I'll be exchanging a few strategy tips with you. Also, if we have the time, I'll tell you a few basic important points about family law. So thanks a lot for your time and attention today. I'll see you guys on Monday. Thank you.